I will be your moderator for today's webinar, and I am super excited and lucky to be joined by two legal scholars. Ahilan Arulanantham is the faculty co-director for the Center of Immigration Law and Policy at the UCLA School of Law. I'm also lucky to be joined by Karen Tumlin, who is the founder and director of the legal nonprofit, the Justice Action Center. To save time, because we have so much to talk about, we're going to put the bios on the webpage. So please go and read more about Karen and Ahilan so you can see just how brilliant they are and how lucky that they are giving their time today to help us break down the Supreme Court. A quick note about the American Immigration Council. For those of you unfamiliar with our work, we are a nonprofit organization that believes the U.S. immigration system should be just, fair, and welcoming. We pursue this objective through a multi-pronged approach, including impact litigation, which is the work my team does, and the work that Karen and Ahilan also do. We do advocacy, research, transparency efforts, narrative change, and we are constantly trying to expand access to counsel for immigrants. A couple of housekeeping matters before we dive into the subject at hand. We will be sending out a recording of this webinar, and it is being live streamed. And we will also have a few minutes at the end for a Q&A. We will try to get as many questions answered as we can. But let's jump in. Today, we're going to be talking about 4 immigration cases that the Supreme Court decided and what they mean for immigrants and for the future of immigration law and policy. We're also going to be looking ahead to the next Supreme Court term and discussing some trends that we're going to be seeing from the court, the good, the bad, and the ugly. I unfortunately think it's going to be a lot of bad and ugly, but hopefully we can infuse a little bit of the good in there too. So let's start with the big blockbuster case from the term, and that was United States v. Texas. I'm going to give a brief overview of what the case was about and the holding, and then I'm going to ask a bunch of questions to our smart experts to help us break down what it means and what happened. US v. Texas is a case about the legality of the Biden administration's policy around which non-citizens to prioritize for arrest and removal. In 2021, the Secretary of Homeland Security issued a memo laying out 3 categories of non-citizens who would be, quote, enforcement priorities. It became known as the Enforcement Priorities Memo. Those priorities were those who posed a threat to national security, to public safety, or border security. The states of Texas and Louisiana sued, arguing that the immigration statutes required the federal governments to arrest and deport certain non-citizens, and therefore the enforcement priorities were unlawful. The lower courts agreed. The Supreme Court, however, held in an 8-1 decision that Texas and Louisiana lacked standing or the legal authority to bring the case. So the court never got to the question of whether the policy itself was unlawful. In writing for the majority, Justice Kavanaugh reasoned that the decisions about whom to arrest and deport are squarely in the discretion of the executive branch, and the Supreme Court shouldn't weigh in on those decisions and those policies. So he reasoned the courts lacked standing to bring the case. Karen, Ahilan, were you surprised by this result?
You want to start, Ahilan? We have different takes. You go first.
Sure. And I should say first, thank you very much for having me, Kate. And it's always a pleasure to do this event. Excited to do it again. Yes, we talked about this in advance and we had different reactions. I was surprised. I listened to the oral argument, followed the case closely for a variety of reasons. And, the Chief Justice in the argument, he said many things, but I remember him saying, what if shall just means shall? And so the government that's what the law says. The government has to detain everybody. And if they can't, then, that's their problem. But our job is just to say what the law is. And I really read that signal to mean that, the government was going to lose this case. So I was, in that sense, pleasantly surprised. We'll get into it, I guess. I'm not sure the decision makes that much sense, although, we'll take it. But I was quite surprised by the result. I actually anticipated Texas winning this case, but Karen was not.
I was not. And what do we have to go on, right? Like I always say, anytime I get asked a question to predict a case or about this Supreme Court, I'm always like, well, I don't have a Supreme Court crystal ball, but I like to pretend that I do. But listening to the argument and reading the papers, I thought it would be a win for what I would consider our side, those of us who are immigration advocates, and for enforcement discretion. And I did think it would be on standing, because I didn't think that this Constellation of Justices really wanted to reach the merits of like what was in this memo and did they agree with it. But I was hopeful that the stakes were just too high, right? And so one of the things, when I have thought about the last kind of 2 to 3 terms at the Supreme Court, and where we have seen immigration cases where those of us who are immigration advocates have wanted to celebrate, I think oftentimes there was a casting of the case that was not solely about immigration. So in this case, it was, well, what is state standing? And we have so many kind of either red state challenges against a blue president or blue state challenges against a red president that I think the Supreme Court was starting to get a little sick of that. And what are the rules of the road on standing? And then on the flip, well, wait a minute, don't all enforcement agencies have inherent discretion to non-enforce? And if we say something here, even if it's immigration, and we might not like that very much, what are the spillover effects? So for that reason, my hazy crystal ball made me think that this would be a win for the ICE priorities memo, but you don't get them all right.
But we will keep looking into that crystal ball and we'll keep making our predictions and hoping we at least get 50-50. Ahilan, what are some of the governing principles to take from this case, if any? And I guess conversely, what didn't the Supreme Court get to in this case?
No, it's a very, very narrow majority opinion. The Kavanaugh, the opinion for the court was written by Justice Kavanaugh, is very, very narrow. And so I think there are very, very few governing principles to take out of it. The court holds that when it comes to challenges to enforcement prioritization decisions, the states lacked standing to bring that challenge. Some of that was an application of this very seemingly basic and perhaps more general principle, Linda RS, which is the cost to the state are indirect. I mean, that's the logic of that case. But then there's a whole bunch of the opinion, which is actually saying, but it's particularly so in this context where what you're challenging is an enforcement discretion decision. And then there's all this reference to case law about selective enforcement and other forms of enforcement discretion challenges where the government wins them. None of those are standing cases. Heckler v. Cheney, Reno v. ADC, and the other cases are not, to some extent, Arizona v. US decided in that same, and none of those are standing cases. So it's an odd move to take that into the standing analysis. But the effect of that, I think, is to allow the court to narrow the decision in a bunch of ways. I mean, they leave aside whether the same would be true of a program that not only was enforcement discretion, but also conferred benefits, which obviously is DACA, and they even cite the CF or something to the DACA case in that. It also allows them to not have to decide the state standing question that Karen alluded to earlier, which is a huge question sort of looming there, which is, in theory, any program, the state standing theory advance here basically is any federal program that causes any additional dollar, like $1 additional of state spending, is then an injury to the state, and for that reason can be challenged. And on the one hand, it does seem like a lot of cases have embraced some version of that. But on the other hand, if it's true, literally every federal policy in some way or another affects, if you cause more people to go from here to there, so many ways in which you affect standing, that seems like everything is up for grabs. And that's a tricky question. And they allowed them to duck that because this is only about enforcement discretion. So it doesn't raise, questions about those. And then also there's this sort of looming war over, which is what I was most interested in this case, beyond, of course, the fate of the priorities memo itself, is whether or not the APA allows for a set-aside remedy, which is essentially the equivalent of a nationwide injunction. A couple terms ago, last term, the court had tried to essentially kill off class-wide injunctive relief, brought case that we have litigated actually challenging detention practices, in this case, Alamán González, and they'd said it was foreclosed by this particular immigration statute, 8 U.S.C. 1252 F1. And the states were arguing here, well, we don't need that. We can get the same thing, effectively the same relief through a nationwide set-aside injunction under the APA. That's what Justice Gorsuch's concurrence was about, by the way. But the majority did not decide that. It's a huge question because it allowed individual immigrants could do the same thing. And then we could get back what we had lost in Alamán González to a large extent by doing that and allow them to duck that. So they ducked kind of all these different tricky questions, both for immigrants' rights litigators and for future state litigation and for DACA. But the effect of it is that it's a super, super narrow opinion. The only thing it really forecloses, I think, is challenges by states to other enforcement priorities policies.
Yeah, and I think if you read Justice Gorsuch's concurrence, you can see he was so eager to take on this nationwide injunction issue, which we've been talking about for years. And I do think we just kind of skated by in this decision by not getting a decision on a nationwide injunction, and frankly, saving that for another day, for another case, maybe for next year, maybe sometime in the future. Karen, does the sort of narrowness of this decision really kind of cabin its utility? Are we just talking about enforcement and removal here? Certainly Justice Kavanaugh was going out of his way to make it just about prosecutorial discretion in those activities. What do you think?
I think so. Definitely maybe is what I think as a top line, but I was making a joke when I read, so I'll say kind of two things at a top level and then kind of dig on where I think this might be going with current cases. So at a top level, I was reminded yet again with this decision that when you just get the slug line, you don't have all the details. So, right, like when you're like following SCOTUS blog, the decision is dropping, no standing for Texas. And, I was like, wow, the impact of this is massive. And then like you both are pointing out, then you start reading it and you read the majority, then you read the Gorsuch concurrence and you're like, wait a minute, how do I piece this all together? This is such actually a big ruling that at the end of the day says so very little for other cases. And so on one hand, I could see like the 28J letters writing themselves, right? And certainly, that was something that Ahilan and I have a case together where we were like, all right, how do we apply this? But on the other hand, I think it's really Kavanaugh maps several open questions when you hold that against the Gorsuch concurrence, which frankly, if the Gorsuch concurrence was the majority opinion, I could use that more in the cases that we're litigating. The Gorsuch concurrence to me has a bottom line on redressability that I think is so clean. And Justice Gorsuch, who by the way was fascinating this term, says, well, we got this part of our analysis, which is redressability, part 3. Don't forget about it. It's important. And it really says, state of Texas, if we rule for you, will you be any better off? And how, Texas, can you show that if we rule for you and we toss out this memo and there isn't a prioritization within immigration enforcement by the agency that you somehow have benefited? And that to me is so clean and so concrete, and would recalibrate these standing fights. But we cannot wield that as the majority because it is not. It is not in the majority opinion. It is in the concurrence. And then, this is what I think we have. I think we have a race afoot in the district courts. I think we have a race afoot in the right state challenges. You can look on our website. We're tracking all of those actually in the immigration context at Justice Action Center /litigation tracker. One of them is this case challenging the Cuban, Haitian, Nicaraguan, and Venezuela parole program that Ahilan's organization, Justice Action Center, and Raíces intervened in. Our judge, sua sponte, brought this up in a status conference we had last week. Now, mind you, it's Judge Tipton. He was reversed here. But he also definitely brought up that the core question that is unanswered is costs, is what Ahilan said. Is it just $1 if Texas shows $1? And he brought it up in the midst of a discovery dispute. We said Texas has not provided information on any reimbursements that they've got. They said, oh, we're harmed, poor us. We're having to spend money in our education system or our medical system, and we're trying to tie it to these parole programs, that they haven't done that. And we said, well, do you get any offsetting federal reimbursements? And they're like, yeah, but haven't provided the information. And so what the judge did was denied the discovery dispute, which is fascinating. Texas does not have to provide that information, and told them, you're on notice, Texas. You can supplement if you have it. And if I decide it's relevant, note the heavy if, and you haven't provided any other information, you've been put on notice that if it matters, it'll be a problem for you at the end of the day. So will he rule first, or will it be someone else? That's what I think is the new kind of fight and challenges.
And Karen, do you think Judge Tipton's use of that if is because we did see in the concurrence, and I think also Alito's dissent, that $1 is enough, $1 of harm is enough? And so do you think that's part of what Judge Tipton was saying was,
Absolutely.
you don't really have to, we know that there's going to be some kid going to school or getting medical treatment?
Absolutely. I absolutely think that's why. And I absolutely think like this is why it's going to be so fascinating what happens, is because individual judges are going to do exactly what we're doing. They're going to pull from the concurrence. They're going to pull from the majority. They're going to pull from and try to fit it together and say, well, this is how I think it makes sense. And this is what I think matters. So there's a lot of open terrain here. And I think, and like, let's not forget, right? It wasn't very long ago where many of us were side by side with blue state challenges to a red state president's administration changes. And we have to look not only at what do we want right now, but long-term, what actually makes sense for this really fundamental building block of how we all bring cases.
Definitely. So Ahilan, this is probably the part of the webinar where if we had a higher production value, we'd have like smoke and fog, and there'd be an ominous voice saying shadow docket. There has been an incredible amount of ink spilled over the last few years, from Twitter to law journals to Stephen Vladek's new book on this topic, criticizing the court's use of the shadow docket. Can you kind of get us all up to speed? What is the shadow docket, and how did it come into play in US v. Texas?
Yes, the shadow docket is playing a huge role in the story of what's happening with this policy and some of the other policies we've been talking about. The shadow docket is, just a cover term for everything that the Supreme Court decides, which is not a product of full merits briefing and argument. So it includes pretty mundane things that every court has to do: extensions of time, enlargements of the briefing, all that stuff is shadow docket. But it also includes requests for stays, requests for injunctions, and basically all of the law about what's supposed to happen during the year plus sometimes that a case is pending before it gets to Supreme Court. And of course, that can happen even from the very lowest, from the district court. So the shadow docket was incredibly important in this case because here, just like we're in front of Judge Tipton in our case, this case was also in front of the case that Karen was mentioning about the parole policy for Cuba, Haiti, Nicaragua, Venezuela. This case was also brought in front of Judge Tipton, and that is, as a great brief by Steve Vladek noted, a product of the fact that Texas has sort of mastered the art of judge shopping and filing in districts where they can pick, almost guarantee themselves, a very conservative Trump appointee district judge. And in this case, the judge issued a nationwide set-aside that is, was essentially the equivalent of a nationwide injunction under the APA more than 1 year ago, on June 10th of 2022. And even though there had been, then the government sought a stay of that. The Fifth Circuit denied it. Then they went to the Supreme Court and they sought a stay of that in the Supreme Court. Steve Vladek filed a brief in the Supreme Court in this case, pointing out that they had judge shopped, in this sort of very grotesque fashion. The government's brief focused heavily on the fact that the Supreme Court had been very critical of nationwide injunctions, including during the Trump administration, when the public charge rule, Trump v. Hawaii, Justice Thomas's concurrence in Trump v. Hawaii is all about how nationwide orders like this are bad. Justice Gorsuch had written a concurrence in the public charge rule where they issued a stay of a lower court decision allowing that to go into effect, where he had criticized nationwide injunctions. And they said, okay, well, do the same thing here and stop this from going into effect nationwide, at least. They said stop it entirely and then at least stop it nationwide while the case is pending. Court denied it without any explanation. And that came, by the way, after the first enforcement priority of this administration, which was a moratorium on deportations for the first 100 days. That got enjoined nationwide. Then there was a second sort of version 2, second generation enforcement priorities policies that also got stopped. And so the effect today, now they win the case today, but it's July of 2023. So for 2.5 years, there's only been certain sporadic periods of time that the administration has actually been able to implement enforcement priorities. And they've had some effect. I won't say that it's not like it's nothing, but it's a massive hit to the administration's immigration policy, which is entirely a product of the shadow docket. And now we find out is illegal. Maybe the moratorium is different actually under the merits ruling here. I mean, the standing ruling here, but certainly the other priorities that they implemented should have been lawful under this, or there should have been no standing, I should say, to challenge them under this policy. The same thing, by the way, happened with MPP. The administration wound down MPP roughly a year, June of 21, that got stayed. And there was a whole year when it was not, MPP continued to operate. And then the Supreme Court said that it was, that the wind down was lawful, essentially, allowed it to go into effect. But again, there was another year that the MPP operated when the administration didn't want it to operate anymore. So the shadow docket has had a huge role. And it's really, to me, that sort of the paradigm example of the dramatic inconsistency that you see in the Supreme Court. And the nationwide injunction example, I think, is a good one. But if you just look across the board, Muslim ban, public charge, the original lawsuit against MPP all gets effectively stopped by the Supreme Court, either denying staying lower court decisions that had enjoined them. And here you get the opposite. MPP, the wind down of MPP, the prosecutorial discretion memo, where it's going the other way. And the effect of it is that it allows Trump-era immigration policy to last much longer than it would have otherwise.
So we're seeing a trend from the last couple of years, at least, that you can lose on the shadow docket and ultimately prevail in the merits. But in the 1.5 to 2 years it takes to get through the Court of Appeals and the Supreme Court, that policy is not going to be in effect.
Exactly. That's exactly it. Yeah.
And go ahead, Karen.
I mean, I'll just add just to that point, right? Like the Remain in Mexico case is a prime example of this, right? So let's think. So the conventional wisdom, of course, used to be you lose on the shadow docket, you lose on the merits. That's what happened in the Muslim ban. That's not what happened in Remain in Mexico, but look at the impact on the administration. So Biden campaigns on shutting down the Remain in Mexico program, issues first a pause, and then the memorandum terminating the program. Texas sues, wins an injunction, and the shadow docket keeps that injunction in place, which is so far reaching, it requires the administration to affirmatively take steps to negotiate with the government of Mexico and stand the program back up and start putting humans back into the program. And they do, for the 1.5 years that it takes for the case to wind its way up to the Supreme Court, where the Supreme Court says, this is crazy. You didn't have a right to issue the injunction in the first place. See Aliman, and certainly not an injunction that required these kind of steps. And so it's that very strange inconsistency of you can win, even though you're not ultimately going to win. And it's a use of delay. And then the only thing is we're all talking about this, and Ahilan made the point that maybe the criticism is working, right? Maybe thank you, Steve Bladdick and others who have really, sounded the alarm about the shadow docket and how sketchy it has been and how, frankly, seemingly political it has looked. Maybe there's more pause in members of this court in what they do with the shadow docket. And we saw some of that, for example, with the mifepristone case this year as well, right? Where again, enormous impact, pretty bold decision upending decades of FDA approval. And ultimately, and they kind of eked it out. Alito issues an admin stay, and maybe there were 2 admin stays before they finally do say, no, we're not going to allow this to take effect while we consider the case. But the last thing I want to say is, in the prior administration, the shadow docket was very much a weapon used against us, I think, in our side. The amount of work that we often had to do because the Supreme Court was seemingly open to multiple shadow docket requests and cases really ups the ante for litigation. In the DACA litigation, that case went twice on the shadow docket to the Supreme Court. Now, actually, it was both instances were a denial for the side of the Trump administration, but for limiting our discovery. But the churn and basically the amount of capacity drain that it took to survive that type of litigation is really a disincentive.
I want to turn to one of the big doctrines that came out last term, the newish doctrine, the newish doctrine, the major questions doctrine, Ahilan, that we talked about back in September in a case, West Virginia versus the EPA. the Supreme Court discussed this new major questions doctrine. And the holding of that case is that the court should essentially overrule federal agency rules and policies that affect, quote, vast economic and political significance. Somewhat of a squishy standard there. Ahilan, is there some tension between the major questions doctrine where the court is skeptical of federal agencies setting rules and policies and is there tension with the major questions doctrine and a case like US v. Texas, where Justice Kavanaugh is saying, we're not going to touch that. That's the executive branch. That's enforcement and removal. That's not our job. Is there tension, or can we just explain this away by this is an immigration enforcement case?
I mean, I definitely think there's tension. And I should say, I understand major questions doctrine. I think there's two strands of it, and it's totally unclear because it's sort of being made up as we, in real time here, as we watch. One version of it is just that Congress has to be clearer than it sort of otherwise would have to be when it is delegating to an agency a decision of, vast economic and, political significance or whatever that mushy term is. And then another version of it is essentially like a non-delegation idea, an idea which was sort of abandoned a generation ago in constitutional law that's kind of coming back to life, which is there might be some decisions that are so significant that agencies don't have the power to make them. And so we're construing statutes to avoid the constitutional problem arising from the non-delegation principle, right? And I think which of those two things it is might matter a lot, actually, as this doctrine continues to develop. But yeah, there's an obvious tension with a lot of the way the Supreme Court immigration cases have run and major questions doctrine. I mean, the Immigration Service is a federal agency that imprisons people, that deports them without any jury, and none of the protections afforded to criminal process. And also at a programmatic level, if you're talking about, say, the Muslim ban, which is like we're going to stop all immigration essentially or virtually all immigration from a set of very large Muslim majority countries, or pick your case, DACA, we're gonna change the immigration status and employment status of 800,000 people, or the temporary protected status. I mean, all of these are massive cases that involve the lives of hundreds of thousands of people. And yet, for the most part, a lot of what we have seen is deference to agency decision-making, either entirely, as in the case of Muslim ban, or via sort of very deferential or rules that limit drastically the extent of judicial review over agency decision-making, like with Patel v. Garland, for example, in a lot of these situations. And, they don't all map exactly perfectly. I won't say it's one, but at a sort of 30,000 foot level, there's an obvious tension between these two things, right? So yes, I do think there's a lot of tension between them. And I think you can't tell it's a complicated question. You can't tell the whole story without also looking at another line of ad law cases which are happening now. Actually, Axon is a case from this term, which is an example of this. They're also another thing the Supreme Court is saying is that there's a set of administrative decision makers who are insulated from political sort of control because they have the tenure protections of the civil service and things like that. And they're saying that there's a lot of people who have that who shouldn't have that. And that actually the political branches have to have more control over the administrative agencies than they do now. And it's some of the very basic, Axon is about a very basic challenge to I can't remember which, I think it's the SEC and the FTC maybe. It's very, very, really sort of existential challenge to whether the agencies can operate the way they do, or instead whether a lot of the people who are part of the bureaucracy have to instead be subject to more direct political control. And so you have these kind of cross-cutting currents happening in the administrative law between these two. I do think no matter how it ends up, I'd be very surprised if the effect of it is to give greater liberty protections to immigrants, because I feel like there's tons of immigration exceptionalism all over constitutional law. And it's hard to imagine this court, there being 5 votes anyway in this court for charting a path that would lead to proper recognition of the fact that the agencies do exercise a lot of quite arbitrary power over the lives of immigrants. So that I feel like what you'd want to have come out of major questions doctrine. Yeah. But I'd be kind of surprised if that's where it ended up.
Yeah, I share your lack of optimism. You mentioned DACA, which I think we have to pivot to. I feel like everyone's eyes are now on DACA and how US v. Texas might be used, might not be used if DACA gets back up to the Supreme Court. Karen, can you just kind of get us up to speed? Where are things at with the DACA litigation?
Yes, DACA. Okay. One of my favorite subjects because of the individuals who qualify for DACA. So the DACA case right now is pending before Judge Hansen. And so I'll do a plug for folks if you want updated information on that case. Always check out the Mexican American Legal Defense and Education Fund on their social media accounts, because they are counsel in that case representing DACA recipients, as is the state of New Jersey. Those are the people on our team trying to protect the people of DACA and the program. So the case is back before Judge Hansen, District Court. How did that happen? It very oddly was remanded by the Fifth Circuit because of the finalization of the notice and comment rulemaking. And the Fifth Circuit, in a somewhat surprising move, sent the case back down, even though all the parties recognized that the finalized rule was a mirror image of the 2012 memorandum starting DACA that Judge Hansen has already found to be unlawful for multiple reasons. He is expected to rule somewhat soonish, but definitely not before this week. All roads lead back to US versus Texas. The parties put in a flurry of notices of supplemental authorities telling the judge how that decision did or did not apply. And the state of Texas was like, Your Honor, these are a lot of pages. We would like until Friday, July 14th to give you our response. There's no reason to believe that Judge Hansen is going to rule before letting Texas respond to that. But after that, it is fully briefed. Supplementation from all the Supreme Court decisions are in. It was argued again in court in a multi-hour argument. And one, at least from my read of that hearing, one got the sense that this is a judge who is out ahead. Maybe he's been working on his ruling. And I do think we'll hear from him soonish, but nobody's got a stopwatch on these judges. Could it be July? Sure. Could it be August? Yeah. Could it be September? Yeah, could be that too. We don't exactly know. But then what? Then the case goes to the Fifth Circuit again. And so the question everybody wants, and what are they going to do? Well, probably exactly what they did before, which is say that they also believe that the program is unlawful for multiple reasons and based on their DACA precedent. That this is in the summary judgment posture, and the Fifth Circuit is not a fast-moving animal. And that's going to take probably a year, if not longer. That's what it took last time this case was up before the Fifth Circuit. So I don't believe this case is going to the Supreme Court this term, unless we have an unusual shadow docket event, which I can talk about briefly. So if you think of that, let's say Judge Hansen rules as quickly as possible, sometime late in the month of July. We shouldn't expect to see a decision until July 2024, when we'll be doing this again, talking about the roundup of the Supreme Court term. So we are, no joke, looking at a Supreme Court trajectory that is after the presidential election, which is going to likely matter more for the livelihood of the DACA program than the court decisions in the short term. The only wrinkle that we could see, which I continue to believe is unlikely, and I say that specifically for any DACA recipients in the audience or people who love and work with DACA recipients, is if the stay on renewals, that is allowing individuals who hold DACA today to continue to renew their DACA and work authorization, is lifted. I want to be very clear. Judge Hansen cannot lift the stay. The Fifth Circuit took that away from him when they issued their decision last October, saying that only issuing a new stay of their own to keep renewals in place and advance parole travel, and saying only they or the Supreme Court could lift the stay. Because the Fifth Circuit didn't want to lift the stay back in October, I would find it quite unusual if they lifted the stay when the case moved back to them after Judge Hansen rules. So I'm very hopeful that we're looking at least a year of solid ground and protection for renewals and advanced parole for DACA recipients. So let me pause there and see, Kate and Ahilan, what else you want to talk about with DACA. That's where the case is and what DACA recipients need to know.
Well, maybe that's the good news of the webinar. Maybe we should just end at 1:35. No, I'm kidding. That is much more promising than I think some people were thinking about it. I guess the question is, if the case does get up to the Supreme Court this term, or in the current posture, you mentioned that it's in motions for summary judgment. How, if at all, will this case be different than when the Supreme Court heard DACA a few years ago in the California Board of Regents case?
Yeah, so, and I'm not an unbiased observer. I was counsel in the Regents case and the Bataya case, which was joined with it. And so what is different, obviously, is the legal posture. In that Supreme Court victory for DACA, we were challenging how former President Trump had terminated the DACA program and saying it was unlawful. We won. We won on that because, very like in the heartland of the Administrative Procedure Act, there was just no real consideration of how this severe change in policy would impact the humans, the 800,000 humans in the process. And that was held to be arbitrary and capricious. So the difference here is this is an underlying legal challenge to, is DACA legal? Yes or no? Does the president have the authority to issue a categorical eligibility deferred action program that combines with work authorization? And that will be the question that is presented to the Supreme Court if it goes up again. And its impact is obviously most importantly on the humans of DACA, but the impact for the scope of executive authority on immigration is massive. When we won the Regents case, where case law was left on immigration authority, it's US versus Arizona, right? It's what we saw in US versus Texas, even though it was a standing decision. There is discretion. There is inherent discretion built into the system. This challenge could change that. The last thing I want to say, though, about what is different, I want to say one thing that is not different. No one thought we were going to win the DACA case last time around. When we walked out of that argument, all of the conventional wisdom was that it was already dead in the water. And you know who didn't believe that? DACA recipients. They also didn't believe that it was a dead in the water idea that President Obama would create this program, but that's what they were told by, folks in the kind of establishment advocacy circles when they began the campaign to create DACA. And so I just want to say, maybe we'll talk some about this in terms of what was Justice Kavanaugh saying when he cited the DACA case in the US versus Texas decision. I think there's always hope for a win on the DACA program, even though I recognize this is uphill given how case law has gone. And that is because the people in the program is wildly popular on both sides of the aisle. It has been, and DACA recipients tend to figure out how to cut the path to what others find to be impossible.
I think I agree with all of that. I would just add a couple of things to it. I definitely agree. You can't predict can't read the tea leaves, and it is definitely true that that the Supreme Court could uphold DACA in its entirety. If I had to put money on it, my guess would be that they would distinguish between the pure enforcement part and what they call the benefits, the employment authorization part, and say that the prosecutorial discretion side of it is legitimate, but the employment authorization side is not. So they would decouple those. And I think you see that obviously the hint of that in the way that the court's opinion in US v. Texas says a program that provides benefits might be different, but that could definitely not be what happens too, but I definitely, if I had to think of the most likely outcome, that might be it. The other thing I would say is that, you, as Karen says, you can't underestimate the kind of political power and of, how that influences the court. When you were talking earlier about shadow docket criticism, and how it seems to have perhaps shifted the court's, approach in general. I think the same thing is definitely true of DACA to some extent, right? DACA would not. It's true that the legal theory, people said it couldn't happen, and then it happened. It's also true the politics have shifted over time and made it much more defensible politically, and therefore sort of shifted the Overton window, quote unquote, to make it like this. There are things that could happen now that could change the Overton, the sort of political strength associated with it. The thing I would love to see is some of the organizations that filed amicus briefs, all these, internet companies and other, all these, companies saying, oh my gosh, these people are so important to us that we can't imagine what it would be like to lose their benefit to our company. Have some of those say, and this is actually a good segue into Hansen, which I know we'll get to in a minute, how about some of those people say, we're not going to fire them. We're not going to fire people who have worked in our company for a decade and are now some of the best employees that we have, or we just think it's wrong and we're just not going to do it. that would obviously be in and of itself like a civil disobedience campaign at a level, at a certain level. But, and of course, it wouldn't have to be internet companies too. It could be all kinds of organizations. DACA, they're employed in every sector of the economy, right? Doing something like that, I think, would make it more politically cold for the court to ultimately end the benefit side of the program, in addition to the prosecutorial discretion part of it.
I like that idea. You heard it here, folks. First here. We could talk about DACA for another hour. I'm going to move us on, though, to one of the other decisions that was decided, which is Santosacuria versus Garland. Now, this is a much more technical decision than the sort of big policy blockbuster that US v. Texas was. And it's a question about the immigration statute that governs when federal courts can hear cases arising from the Board of Immigration Appeals and what non-citizens must do to exhaust their claims before they get it up to federal court. The Supreme Court held in a 9-0 decision that non-citizens subject to deportation do not have to exhaust their claims before going to federal court and don't have to ask the Board of Immigration Appeals to reconsider their decision. To put this more simply, they don't really have to ask the Board of Immigration Appeals for a do-over before they can take their case up to the Federal Court of Appeals. But I think what might be most noteworthy about this case, Karen and Ahilan, is that it was decided 9-0, which virtually never happens in immigration cases. And Karen, what do we take from a 9-0 decision on a matter of immigration law? Is this just about preserving federal court jurisdiction, or could it represent some mounting skepticism of the Board of Immigration Appeals, the immigration agency that decides appeals?
I actually think that this is like the lurker immigration decision of the term in many ways. Because I have to say, as I read it a second time, it is just so fascinating to me. And I'll say just a couple of words around why. First of all, you got to wonder, what was this case even doing at the Supreme Court in some ways? And this is what I really mean.
Yeah.
It's 9-0. You go through the statute, and the specific provision that is being challenged, that the federal government is taking the position is both jurisdictional and requires exhaustion. No, it doesn't. All of us who practice in immigration know very clearly one of the arguments, it's like the second argument Justice Jackson makes. All over Section 1252, there are hardcore jurisdictional provisions. There are a whole bunch of them. We have litigated the heck out of them since 1997, and they all begin with certain words that say some version of no court can, notwithstanding, and then they cite a habeas statute sometimes, the following. This provision does not say that. And if we know anything about what jurisdictional precedent tells us is, yeah, Congress can remove jurisdiction, but they must be completely clear that it's what they meant to do. And so honestly, when I look at this, I think, oh, wow, is it Supreme Court tradition to always give the newest justice an opinion to write where it's 9-0? Because it sure seems to me like that has happened every time we've added a justice. And then I think, is this just the Supreme Court doing its job properly? And by that, I mean, what is most fascinating to me is the footnotes on the circuit split. How in the world did so many circuits line up on the side of thinking that this was a jurisdictional provision? And so I think that the Supreme Court took this case in order to right the ship on a very clear statutory interpretation question. And then the last, and kind of for me, from my seat, most important part of this is, oh my God, how many immigrants suffered under these incorrect interpretations for so long? Even in this decision, you get just a tiny snippet of who the immigrant is, a transgender woman, right? Who the immigration judge says, you suffered past persecution. You have a presumption that arises of future persecution. And the gotcha is you didn't erase this basis before. And so you have to wonder, in a case that is 9-0, in a case where you're like, how do we even get to this state? How many people were trampled under this interpretation? And last, and let it not be least, why in the world did the Biden administration and the Biden DOJ take the position that they took here? There is no rule that says they have to be on the side against immigrants in cases like this. And the fact that in their zeal to narrow the types of litigation that can generally be brought under 1252, that they had tried to apply that to this specific statute. I do think we should be having words with the Biden DOJ about why they pursued this case in these positions.
Yeah, and I think that's been one of the disappointments of being an immigration litigator in the Biden years, is that they're not changing position more often. Well, Hansen, the next case we're going to talk about, I think there was a tweaking of the position a little bit from the Biden administration. And the Hansen case is a really interesting one, where the court was examining a section of the immigration law that forbids encouraging or inducing a non-citizen to enter or reside in the United States. The court held that this provision does not violate the Constitution's free speech clause. And in so doing, the court reversed the Ninth Circuit's holding that the statute was overly broad because it swept in constitutionally protected speech. Now, the court sort of tried to narrow or cabin what the statute does, saying that a person has to intend to criminally encourage or induce unlawful entry or residing in the United States, and that it was functionally equivalent to the traditional elements of solicitation or aiding and abetting. So, Ahilan, setting aside the sort of constitutional principles at play here, free speech and overbreadth, can you, for a minute, give us a sense of context? Who was watching this case and why does it matter? I think, Ahilan, you're frozen for just a second, but I was just asking you the case.
I'm back.
Okay.
Sorry, so sorry, I'm having the internet. Could you repeat the question, please?
I was asking the question of the context around Hansen, which is who was watching the case and why does it matter?
Yeah, Hansen's an incredibly important case. It was being watched very closely by legal service providers, by universities. I mean, I was watching it very closely. We do a lot of work here at the Center for Immigration Law and Policy with undocumented students who do not have DACA, and UC as a whole provides a huge amount of services to such students. And if you took the version of the statute that the government had defended at the trial, right, that version under which there's no requirement that you intentionally solicit or facilitate a specific immigration act. I mean, they rejected, they argued against, and they won a jury instruction that would have required that element. Then it opens all kinds of scary hypotheticals, right? Like a person who gives advice and explains how a student can get a scholarship and therefore stay in the United States, or people who advise that the government is unlikely to come after and arrest someone who overstays a visa, or, and there's a million other examples like this, some of which are discussed in the dissent. There were real concerns by that, and there were amicus briefs, one by Asian Americans Advancing Justice, another one by the National Lawyers Guild and other legal service providers, talking about how the legal service providers are very concerned about it. I should say also, what the court did wasn't just sort of try to. I mean, the court said that this statute, despite it saying encourage or induce, which are obviously extremely broad words, only punishes the intentional solicitation or facilitation of specific immigration violations. And so it reads the word induce to mean solicit, even though induce is obviously broader than solicit in normal language. And it reads encourage, which is a super broad word you would think, to mean aiding and abetting, or assistance or facilitation. I mean, and says those are terms of art. They're criminal statute terms used elsewhere, like in the neighboring provision, and they read that back into this statute in order to dramatically narrow it. So I actually think it's a grossly implausible reading of the text. Congress had actually deleted those exact words that they read back into the statute in 1952. And I could sort of go on and on about all the reasons why this decision is sort of very wrong as a technical matter, but it is. I mean, I think you could imagine three worlds. Like, world one is the world that the government argued for and won in the district court. which puts a huge amount of work that immigrants' rights organizations do at risk. Also like people who leave water in the desert. There's a brief, actually, it's on behalf of, I believe it's FIRE, or it's a group talking about how churches, a lot of religious organizations, do work that is now in jeopardy because of this. So that's like world number one. World number two, which is what the court did and what the government argued for, later after they had won their conviction, was narrow the statute dramatically to do essentially what the court did. Read it as a typical solicitation and aiding and abetting statute. And then there's world number three, which is what the defendant was arguing for. And I should give a plug. Aisha Bandari from the ACLU did a fantastic job arguing this case in the Supreme Court. But what she was arguing was that the statute is overbroad and therefore is unconstitutional because it sweeps in too much protected speech. So they were actually arguing you cannot read the statute narrowly, and if you read it as broadly as it has to be read, it's unconstitutional. You should strike it all down. But the middle path was, no, read it extremely narrowly to include only specific intent to facilitate these kinds of unlawful conduct, and that's what the court did.
Essentially, the court wrote into the statute an intent requirement that isn't there. And according to Justice Jackson's, what I think is a very compelling dissent, should not be written into the statute. But nevertheless, that's essentially what the court did, right?
Yeah, and the textualism here is really crazy. It just shows you how absurd. This is the one of the arguments. She makes a bunch of good arguments. To me, the best argument is these were the words of the statute in 1952. Yeah. Congress deleted them, and now you have read back in exactly what they deleted. That's just no. It seems so straightforward. But the other thing is that they're pointing to dictionary definitions which use the broader term to define the narrow one to mean they're synonymous. Like, if I say, what is a chair? A chair is a piece of furniture. It does not mean that all pieces of furniture are chairs. Like, it's obviously wrong, but that is how dictionary definitions work, because it helps you, it helps you define what the term is. And she makes this sort of basic point, like, what are you people doing? This is so obviously wrong. But I do still think it's not a full win. Obviously, it would be better to strike down the statute entirely. But I think now, in a world where general counsels of universities or of government agencies, for that matter, are looking to see, hey, can we authorize, if you're a government agency, or should we fear, if you're a university or a legal service provider, prosecution based on these very broad theories? Now, I think you can look to this case and say, well, no, the court has read this statute to be just like a traditional solicitation or aiding and abetting statute. And if you are giving water to people, because you don't want them to drown, to die of dehydration in the desert, that doesn't mean that you encourage them to come here. Your intention was just to help them not die, and that is not itself a crime, and so cannot be criminalized under this provision.
Yeah. I want to briefly mention the fourth case that the court decided, which is Pugin v. Garland. It's a case about the intersection between criminal law and immigration law again. And federal immigration law requires the deportation of non-citizens who are convicted of an aggravated felony. And one of those aggravated felonies is an offense relating to obstruction of justice. In Pugin, the court was deciding whether an offense relating to obstruction of justice required an ongoing investigation or prosecution. Rejecting Mr. Pugin's arguments, the court found that it does not require that ongoing investigation or prosecution, and so sort of refused to narrow the application of this offense to the aggravated felony provision. Karen, one of the interesting things about this opinion is that it doesn't make any mention of the lower administrative body that we talked about earlier, the Board of Immigration Appeals. There are mounting signals that the court is ignoring the Board of Immigration Appeals. And we're also going to be seeing a case up at the Supreme Court next term on deference to federal agencies in a principle called the Chevron doctrine. What are your thoughts about, what the Supreme Court's views are of the immigration administrative agencies?
Yeah, I think it's a really provocative question. And I think Kate is right to point out that, in this decision, impeachment, which is 6-3, with Justice Kavanaugh writing again for the majority, with a very fascinating lineup where Gorsuch is joining with Kagan and Sotomayor in dissent. There is no matter, the BIA is invisible, and yet they have a very big role in the case. And in Santosacuria, same thing. You don't see the Supreme Court in reaching its decision really addressing what they did, and you certainly don't see them deferring to the Board of Immigration Appeals. So I think it puts on our radar a question of, as the Supreme Court digs into Chevron deference, is there going to be a carve out for the immigration administrative agencies, right? Is it going to be like, yeah, we defer, except if we don't think you're a very good administrative entity, Board of Immigration Appeals, or if we think immigration is special and we're not going to hold the line there as we might, for example, with the EPA or another agency. I think that the last thing that I would say is simply my experience, particularly in immigration, is Chevron deference is really slippery. What we can see is, well, when you like the outcome, you're going to defer. And when you don't like the outcome, you're going to say that the statute was clear and not defer, or at least the case law has allowed for that kind of outcome-driven decisions, at least in the immigration sphere. And I think the writing is on the wall that that may continue with a little differential treatment for the BIA.
I think that sounds right. And just as a point of clarification, that case is called Loper-Bright, the Chevron case that would be up at the court. It does not have to do with immigration. It's about fishing regulations. But I think everybody who practices before immigration, or I'm sorry, administrative agencies is looking really closely at that case because of all the implications that Karen just mentioned. We have just a couple of minutes left. I do want to get to the new justices this term. Can you kind of zoom out and 30,000 foot view, what did we learn, if anything, from some of the new justices, Justice Kavanaugh, Justice Jackson, Justice Barrett, and any takeaways for immigration litigators, Supreme Court litigators?
I mean, just in sort of 2 seconds or less, I mean, Justice Barrett is definitely hostile to categorical approach. I think we saw that, and you might even more generally say hostile to immigrants more generally, is compared to, say, Justice Gorsuch, who I think is consistently in play in immigration cases in a way that you might not expect, given his sort of his profile as sort of a far right justice. She wrote Patel obviously last term, and where she is in Pujan is another indication of that. Justice Jackson, I was disappointed to see that she was in the majority in that case. But she has a really, really interesting concurrence, actually, where she says that perhaps, the statute should be limited only to actual federal obstruction statutes, federal obstruction convictions, which, if had been advanced by the defendant, or the respondent, the immigrant in this case, perhaps she would have voted the other way. She indicates that possibly might be her view. In general, I would say you look at a lot of her writing; she's just a really interesting kind of thinker, and very kind of incisive approach to to a bunch of different issues. So yeah, that's a little bit of my thinking. Obviously, nothing really fundamentally changes the 6-3 supermajority that we're all living in. But that's a quick take on a couple of them.
And we did see a few bright spots this term. We saw Justice Gorsuch's sort of dissertations on indigenous rights. We saw the Alabama voting rights case, and of course, US v. Texas and the 9-0 Santosacuria. Were those anomalies? Are we just a shifting right court and we need to accept that? And maybe we'll have a couple bright spots every year, but we shouldn't hope for that.
I think it's too early to say, right? I continue to have, and certainly I think that sometimes the bright spots are even more bright when you know how challenging it was for the litigants to kind of get that through the current composition of the Supreme Court. But I continue to believe that there are some justices who are not so ideological driven that they have ruled out ruling on immigration cases on the side of immigrants' rights advocates or immigrants communities. And I still believe that, or at least now, that the Chief Justice has shown himself to care about the politicization of the Supreme Court. The Chief Justice has shown himself over the terms to be an institutionalist, in my view, to actually care about whether Supreme Court decisions ultimately catch up to public opinion. And I think that the Chief Justice might have a little more sway in the court than it looked like perhaps he did last term. And so with that, you know, with seeing, for example, in US versus Texas, the Chief and Justice Kavanaugh writing together, I think that there continues to be a path to, one, advocate fiercely on behalf of how humans in our communities are impacted in these blockbuster immigration cases. And there continues to be a path to achieving Supreme Court victories when we can shine a light on how limiting, for example, executive authority in the immigration sphere might have blowback in other spheres that a larger number of justices care about. And that's kind of the make it not just about immigration theory. I think the trick for us is, how do you do that? Which that is the case. It's so often the case in law, while holding true to what the immigrants before the court themselves want and what their struggle is. And I think that can be done.
Yeah. Well, we are now officially over time. I mean, we could keep talking for a long time, but I want to thank everyone for joining us today for this really interesting conversation. Huge thank you to Karen and Ahilan. I have to give a special shout out to Ahilan, who's actually on vacation, for joining us today. If you liked this webinar and want to keep the webinars going, consider a donation to the American Immigration Council. And while you are feeling generous, head over to Karen's website, the Justice Action Center, and consider supporting her work as well. So thanks everyone for coming, and thanks again to Ahilan and Karen, and have a wonderful Tuesday.
Thanks everyone.